हेलो स्टूडेंट्स। मैं स्वागत करता हूँ आपका अपने यूट्यूब चैनल लर्न एंड एजुकेट में, जहाँ पर हम पढ़ रहे थे कोड ऑफ सिविल प्रोसीजर 1908। हमने पिछले वीडियो में देखा था कॉस्ट 35, सेक्शन 35, अंडर सेक्शन 35, 35A and 35B were also dealing with the cost. Cost was specified that the court may prescribe, but subject to such conditions and limitations, the provisions of the law for the time being in force. The cost of an incidental to all suits shall be discretion of the court, and the court has the full power to determine by whom और आउट ऑफ whose प्रॉपर्टी कौन भरेगा और किसकी प्रॉपर्टी पे क्लेम लाएंगे एंड व्हाट एक्सटेंट सच कॉस्ट विल बी पेड. Any rules, directions for the purpose aforesaid. The fact that the court has no jurisdiction to try the suit shall not bar the exercise of such powers, and the cost term includes where the amount payable by one party to another, the quantum of such amount, the amount, the quantum of this cost, that is the amount of the cost when they will be paid, the fees and expenses incurred for the witnesses, legal fees and expenses incurred, and any other expenses incurred in connections with the proceedings. Then section 35A, compensatory cost in respect of false or vexatious claims or defenses. When any claim made by a defendant just to delay the pleadings, just to delay the proceedings of the court, then the such intentions of the defendant or any other party will be charged to cost. And section 35B deals with cost for causing delay. A suit by the plaintiff where the plaintiff was ordered to pay such cost. B. The defense by the defendants where the defendant was ordered to pay certain cost, to pay the cost. And now we will study about part 2, execution. Under the heading execution, general provisions, section 36, application to orders. The provision of this code relating to the execution of decrees, including provisions relating to payment under the decree, shall so far as applicable be deemed to apply to the execution of orders, including payment under an order, which states that the expression code which the expression the provision of the code relating to execution of decrees, including provision relating to the made payments under a decree, shall be applicable, is deemed to apply to the execution of the order, is deemed to apply to the execution of the orders, including the payments to be made under the order. The payments made to be order will be included under the application of the order, under the execution of the decrees. Now, section 37. Section 37 deals with the definition of courts which passed a decree. Section 35 of a court which passes a decree. The expression the court which passes a decree shall, in relation to the execution of the decree, unless there is anything repugnant in the subject or the context, be deemed to include a where the decree to be executed, where the decree which is to be executed as a definition under the as explained under section 36, the decree to be executed unless there is anything repugnant in the subject or context shall be deemed to include where the decree to be executed has been passed in the exercise of appellate jurisdiction, the court of the first instance, and b where the decree to be executed has been passed in the exercise of appellate jurisdiction, the court of first instance, where the court of first instance has ceased to exist. Sorry. Clause B, where the court of first instance has ceased to exist or to have jurisdiction to exercise it, the court which, if the suit wherein the decree was passed was instituted at the time of making the application for the execution of the decree, would have jurisdiction to try the suits. Therefore, as per A explains that where the decree to be executed has been passed in exercise of the appellate jurisdiction, then the court of the first instance, and where the court of the first instance has ceased to exist, means the court of first instance does not have the jurisdiction to execute it, then the court will, if if therein the decree was passed, was instituted at the time of making the application for the execution of the decree, which have the jurisdiction to try such suits. Explanation is given as the court of the first instance does not cease to have jurisdiction to execute a decree merely on the ground that after the institution of the suit, where the decree was passed, or after the passing of decree, any area has been transferred from the jurisdiction of that court to the jurisdiction of it from the jurisdiction of that court to the jurisdiction of any other court. But in every case, such other court shall have the jurisdiction, sir. Every other case, such court shall have the jurisdiction, sir, to execute the decree. If at the time of making the application for execution of the decree, it would have the jurisdiction, which says that the court of first instance, which ceased to have the jurisdiction to exercise a decree merely on the ground that after institution of the suit, the decree was passed, or after the passing of the decree, any area has been transferred from the jurisdiction of that court to the jurisdiction, where any area has been transferred from the jurisdiction of that court to the jurisdiction of any other court. But in every other cases, such other court shall also have the jurisdiction. Such court shall have the jurisdiction to execute the decree if at the time of making the application, if at the time of making the application for execution of decree, it would have the jurisdiction to try the suit. If at the time of execution of the decree, it would have the jurisdiction to try